Like it because there will be. No. Geze kusaidia wale wale. At least have
Hata ina maana kanashira kwa maana mache ngoja kama ile sente ndio lazima nicho kwa ile kwa na bahati ngwa Simba bwachi ya maana so ngwa ile sente ngwa kwa so mama kwa anachi
It's okay, I'm still a young man.
Kale omulungi ali ku Extreme Media UV wherever you're watching us from. Tuli wano ku High Court, Supreme Court wano mu Kampala era nga tulinze omukulu Dr. Kizza Besigye oli ku Extreme Media UG. From wherever you're watching us, you are watching Extreme Media UG and John Paul is my name. As the heading says, what do you think? Olowooza Kizza Besigye banamuwa bayo? Olowooza kituwe? Ndowooza ya mu comment section wetulinda.
Kamala oyo kati olina ogenda nomugamba kifaananyi kya leero kyakola mu kibadde kyange naye bakitaddemu okukwata ajja kugamba kiwandiikeko
olinde bamulaga bagamba they have got them with their suppressors. It's permanent. feel good about it.
What is that doing? Let me
Just like they take us in their venues in our home district.
When you live once, and I started driving, and it was not actually very difficult.
Well, I really
Yes, let me fast forward some pictures. Ndabi waluwata yipi yuna alemedde apo leero lunaagenda genda yomba
agenda kugamba
Bulani ndala utege kukolera wano
waliwo nokebera
ngamba abadde abali ku MTN nga tali ku Airtel okyuseeyo
nakyusizza yikanda ne wano
kati omuleka yakugamba experience
we are eagerly waiting. We want to post High Court because of what we tulinda mkulu Dr. Besigye ne Haji Rutale. Aketalo kukanjira tuli mukulaba Dr. Besigye amaze okuba nti ayingirawo mu kooti. And from wherever you're watching us from, you're watching Extreme Media UB and Extreme Media UB. Joliko eranga kulaba aketalo kayongedde kiraga Dr. Besigye amaze okuba nti nayingirawo naye gyesitanaba kuba nti no atuukira ddala munda babola abakasabo bola bayambala aba kasitola baabo aba prison nga bayingidde kitegeeza nti bamaze okuba nti no ate olwaleero osuubira kikuno nga heading weri ng'omutwe we guli ogwa live eno kiki kyolowooza kiki kyolowooza olunaku olwaleero olowooza lwekitakeetalesa
That is a Besigye and handled with a versus Uganda.
What's the judge like this morning with this matter?
It pleases your worship. My name is Ernest Kalibala. The team that is representing the applicants is led by my grand friend Elias Mugwango and Samuel Muizi Lindwa, Aaron Kiza, Kunihira Proskovia, Kato Musime, Kakuru Musime, here, Mr. Ivan Owe, E-W-O-W-E, Mr. Farouk Kamrelia.
Yeah, my love. Worship.
Mr. Tugume Moses, Mr. Silas Oguru,
Silas
Oguru, Mr. Seka Jakuhabubeka, Mr. Chifu Michael, Mr. Bayan Nawe, Mr. Isaac Wagala, Mr. Julius Seka. Respondent is represented by Mr. Richard Birikumbuka, Chief of State. That is true, Your Worship.
Richard
Birikumbuka, Chief of State Attorney. Worship, the matter was fixed for ruling. Receive the same.
Well, the ruling is ready, and court instruction to pronounce the same. And the application number 113/2025, arising from Nakawa application number 8 of 2025 at Nakawa Human Report. First applicant, Kano, Dr. Kiza Besigye. 2, Haj Obed Tari versus Uganda. Before Honorable Eight Justice Content Counter Kenya, ruling. The ruling is of 17 pages. Lead counsel, you want each and every word written on this ruling, or you want silent features?
The prerogative is yours, Your Worship. The declaration will be suffice if it pleases you.
And for the one who has not yet, who not get the chance of getting to UPE, yet is interested, we shall pronounce the whole of it, I think, for the benefit of the public. Background. Colonel retired Dr. Besigye and her job hereafter referred to as the first applicant and second applicant, and where the context permits, the applicants were charged with 1. Prison contract section 223, subsection 1, part C of the Penal Code Act, cap 128. 2. Misprision of prison contract section 25 of the Penal Code Act, cap 128. The prosecution alleges that the applicants and others who at between the year 2003 and November 2024 while in various cities, including Geneva, Switzerland, Athens, Greece, Nairobi, Kenya, and Kampala, Uganda, contrived, applaud, act or matter by force of arms to overturn the government of Uganda as by law established and expressed or declared such law, act or matter by utterances and overt acts. In the alternative, the prosecution alleged that the applicants and others to at large in the places and in the time frame aforementioned, knowing that another person intended to commit treason, did not report the same to the authorities or use all reasonable endeavors to prevent the commission of treason. Legal basis of this application. The applicant brought this application by laws of motion under Article 23 or 6 of the Constitution of the Republic of Uganda, 1995, Section 15 and 16 of the Trial on Indictment Act, Cap 25, and Rule 2 of the Judicature Criminal Procedure Application Rules, for orders that A. The applicant be admitted to bail and released from remand/custody. The grounds of this application stated in the application and further detailed in the affidavit in support deposed by the applicants are briefly that on the first day of February 2025, the applicants were charged with treason and misprision of treason at the Chief Magistrate Court of Nakawa and remanded in custody. The offences with which the applicants are charged are only bailed by this honorable court. C. The applicants are responsible citizens of Uganda who have permanent places of abode as follows. First, applicant at Wilinja LC1, Wampewa, Katanga Town Council, Wakiso District, and Rwakabengo A, Rwakabengo Ward, South Division, Rukongiri Municipality, in Rukongiri District. Second applicant at Sigula Village Cell, Mutundo Ward, Gongola Samagabo, Makinde Wakiso District, for the second applicant. The applicants are not a threat to any investigative or other processes and are willing to appear before this honorable court for mention or trial as and when once released on bail. E. The assistance of the applicants demonstrate this respect for the law and for all bail processes they have benefited from. The applicants have not been committed to High Court for trial and are willing to comply with all reasonable conditions set for their admittance to bail. G. The applicants are of advanced age and have substantial sureties who are willing to ensure compliance with bail conditions once applicants are released on bail. H. It is fair and just that the applicants be admitted to bail and released accordingly. At the hearing, the applicants were jointly represented by Honorable Elias Lukwaku, Mr. Ernest Kalibala, Mr. Apollo Katumba, Mr. Wanda Samuel, Mr. Samuel Moyezi, Mr. Kodikira Proskovia, MS Kodikira Proskovia, Mr. Kato Musini, Mr. Bayan Rinawe, Mr. Farouk Kamulegea, Mr. Kintu Michael, Mr. Amanya Kofi, Mr. Kato Wilson, and MS/Oguru. The respondent was represented by Chief State Attorney Joseph Chomogendo and Chief State Attorney Richard Birivumbuka. Both the applicants and respondents made oral submissions at the hearing and filed written submissions for which this court is grateful. The said submissions have been considered where necessary. Submission. It was submitted for the first and second applicants as follows. Article 23, 6A of the Constitution of the Republic of Uganda as amended spells out the right of an accused person to apply for bail and enable this court to grant bail on such conditions as it considers reasonable. Section 15 of the TIA, Cap 25, provides that this honorary court may at any stage of the proceedings release the accused person on bail. Under Section 16, subsection 1 and Section 16, subsection 2 of the TIA, court may grant bail if an accused person is able to prove exceptional circumstances and that they will not abscond from the trial once released on bail. Counsel cited the case of Attorney General versus Joseph Tumushabe, Constitutional Appeal number 3 of 2005, Supreme Court, where it was held that it is no longer necessary for the applicant to prove exceptional circumstances before they can be granted bail. Counsel further cited the case of Foundation for Human Rights Initiative versus Attorney General, motion petition number 20 of 2006, where court observed that the provisions of Section 15 of the TIA were only regulatory and did not take away the discretion of the court to grant bail in deserving circumstances. One of the exceptional circumstances that listed in law is one of the exceptional circumstances listed in law is advanced age. As it is provided under Section 16, subsection 3A of the TIA, and that guideline number 4 of the bail guidelines interprets advanced age as the age of 60 years and above. Counsel further submitted that the applicants are 68 and 65 years old respectively, and that owing to the advanced age of the applicants, they are not able to manage the harsh conditions in prison. Counsel for the applicants added that the applicants have been in custody since 16 November 2024, a period exceeding 120 days without being committed for trial. Citing the case of Besigye Charles versus Uganda, application number 8 of 2011, counsel said that the courts have recognized that prison conditions are not favorable to the health of old people, who are in any case presumed to be innocent until proven guilty. Section 16, subsection 4 of the TIA and guideline number 13 of the bail guidelines provides that other factors that the court might take into account in making the decision to grant bail is whether the applicant will abscond when released on bail. In support of the fact that the applicants will not abscond, counsel for the applicants said that although the applicants have been charged with serious, grave offenses which carry the death penalty, should the applicants be convicted, the gravity of the offense does not bar this court from exercising its discretion in favor of the applicants. It was further argued for the applicants that the law has allowed applications to be made even where individuals are charged with serious grave offenses. Counsel added that in many decisions of the High Court, bail has been granted to applicants charged with grave offenses, including treason, terrorism, aggravated robbery, murder. that in the case of the first applicant, he has been charged with various grave offenses before and released on bail, and he has not been convicted of any of those offenses. In the case of Makoha Samuel and 35 others versus Uganda, criminal application number 24/2024, the International Crimes Division of the High Court, ICV, had the occasion to consider the question of gravity of the offense vis-a-vis a bail application, and held that despite the gravity of the allegations against the applicants, this court must determine whether sufficient evidence is presented to indicate the guilt or innocence of the applicants. The ICD also held that the fundamental principle for a court to release an applicant on bail is the presumption of innocence, and courts should favor the liberty of the accused, provided that doing so does not compromise the interest of justice. It was further submitted for the applicants that the nature of the offences with which the applicants are charged are political offences, and that these two are not. And on that account alone, the kind of offences in respect of which bail cannot be granted, that the first applicant particularly has been charged with various political offences over the years, offences in respect of which no conviction has been returned by the respondent. Counsel cited Makoha Samuel and 35 others versus Uganda, Supra. Counsel submitted that other conditions to be proved before court include antecedents of the applicant, possibility of a substantial delay in the trial, the likelihood of the applicant to attend court, the stage of the proceedings, the likelihood of committing an offense while on bail, the likelihood of the applicant interfering with the witnesses. Counsel for the applicant cited the case of Panju versus R 1973 Supplemental Reports at page 82, where the court held that allegations of interference with witnesses must be substantiated, and that such substantiation is not difficult to show. Counsel for the applicants concluded by stating that the other factors to consider in the application for bail are whether the applicants have fixed places of abode, have sureties, substantial sureties, and whether there are no other charges pending against the applicants. In reply, counsel for the respondent submitted as follows. Section 15 of the CHI and Guideline 3 of the bail provides conditions that court should take into account in its considering bail applications, including the substantiality of sureties, nature of the offences, age of the applicant, possibility of interfering with investigations and witnesses, possibility of absconding bail, whether the applicants have a fixed place of abode, applicants' antecedents, and sensitivity of the charges. Guideline 15 of the bail guidelines offers guidance on what to consider while determining the suitability of the sureties, the age, work, business of the sureties, character and antecedents of the sureties, relationship of the surety to the accused, both applicant, and other factors as the court may deem fit. Regarding sureties, the first applicant produced 4 sureties. To wait, Honorable Semuju Nganda, a close friend, age 52 years. Honorable Francis Mwenjuche, a close friend, age 41 years. Honorable Mokindo Heron, Tony, a close friend, age 52 years. And Honorable Nicholas Thaddeus Kamara, a close friend, age 50 years. And that the second applicant, produced by Nagita Halima. The second applicant produced Nagita Halima Rutare, a wife and age 58 years. Nafuka Zukura, a daughter age 27 years. And counsel Kambo Hamza, a friend aged 48 years. Counsel submitted that all these sureties presented by both applicants are much younger than the applicants, and this makes the applicants superior to their sureties, and yet it should be the other way around. And that in such a scenario, the sureties are unable to compel and influence the applicants to appear in court in the event that they abscond. I also cited the case of Mogera John versus Uganda, criminal prosecution number 21 of 2025 at International Crimes Division. Honorable Lady Justice Alice Komhani Kauka held, it is my constant view that a surety should possess a certain amount of authority and or influence over the applicant. The sureties presented by the first applicant have no authority and or influence over the applicants, and it will be hard for them to compel the applicants to comply with bail terms and are therefore not substantial. It was further submitted that the bail guidelines require that the letter of introduction from LC1 should state to the court that the surety or applicant is not just a resident but a permanent one in that area. Whether or not the surety has a fixed place of abode is an issue that should be expressly stated in the letter of introduction and not merely implied. Additionally, counsel submitted that the relationship between the sureties and the applicant is paramount and has such bearing on the surety's ability to influence and compel an applicant to attend court when required. The first applicant produced only friends as sureties who don't provide sufficient assurance that the applicant will comply with bail conditions. Counsel added that friends do not have the necessary leverage or influence to ensure the first applicant's compliance, and are most likely unwilling to take steps to enforce compliance. I also cited the case of Kusime David versus Uganda criminal prosecution number 29 of 2019, where Honorable Justice Musa Sekana held that he was uncomfortable with cousins, even if they had fixed places of abode. Counsel said that if court was uncomfortable with the applicant basing on cousins, then what about the instant case where the applicant presented mere friends? It would be more risky to leave the first applicant with just friends as sureties. In his submissions, counsel submitted that the sureties have to prove and assure court that they will deploy their time and resources to monitor, influence, and compel the applicant to appear in court whenever required, and that none of the sureties for the applicant dispense this requirement. Counsel cited the case of Mogera John versus Uganda business application number 2 of 2022, where Honorable Lady Justice Elizabeth Jane Alibiza upheld the above view. It was further submitted that none of the sureties provide their work or business identity cards. What was annexed are passports and national IDs, which have no relationship with the business of employment or gainful income and disposable income, which are critical in assessing their substantiality. In a single Anna versus Uganda, criminal prosecution number 81 of 2024, court held that a job identity card alone is not sufficient to demonstrate the capacity of a surety to meet the terms of the bond. Therefore, failure to demonstrate financial capability by the sureties, regardless of their position in society or government, is fatal and goes to the core in the grant of bail applications. advanced age of the applicants is not the only ground or consideration for bail under Section 15 of the TIA, under which this application was brought. This court has to balance the interests involved as was held in the case of Musime David versus Uganda, criminal distress application number 29 of 2019. The offences with which the applicants are charged with are serious, grave, of public interest, impact on national security, and the applicants will abscond bail. In DPP versus Kano retired Dr. Kiza Besigye, Constitutional Reference number 20 of 4005, the Justice of the Constitutional Code held, among other things, that where there is a substantial likelihood of the applicant failing to surrender or turn up for trial, bail may not be granted for less. Bail may only be granted for less serious offences. The court must weigh the gravity of the offence and all other factors of the case against the likelihood of the applicant absconding. In the case of Foundation for Human Rights Initiative versus Attorney General, Supreme Court Constitutional Appeal number 3 of 2009, the Justice of the Supreme Court held, among other things, that this article imposes on court the duty to ensure that they do not only consider the rights of the accused person applying for bail, rather the court should also consider the interests of society at large. The first applicant has another pending charge pending against him at Uganda Road Chief Magistrate Court, which is part half. Section 15, subsection 4 of the TIA provides other pending charges as a consideration. Court should take into consideration in deciding whether or not to grant bail in an application of this nature. In the case of Honorable Alan Sewanyana Aloysius and Honorable Segiri Mohammed versus Uganda, Masana Criminal Application number 18 of 2021, Justice Lawrence Toyanze, while dismissing the application for bail, held that in an early application granted the applicant's bail, Lady Justice Victoria Nakin, based on the fact that they had no other charges pending against them, but at the time of determining the present application, they have charges of murder against them, in addition to those they were earlier charged with. It was therefore submitted for the applicants, for the respondent, the pending charges against the first applicant are a good ground to dismiss his application since he committed the current offences while on bail, via Uganda criminal case number 624 of 2023. In the rejoinder, in respect to the fixed place of abode, it was submitted for the first and second applicants that whereas the respondent contends that both applicants do not have fixed places of abode because they do not provide land titles or tenant agreements to show the fixed places of abode, and therefore they may not be located or held accountable if they jump bail. Counsel for the applicants submitted that both the first and second applicants provided evidence on oath by way of 2 affidavits and attached LC1 letters in support by each applicant about their respective fixed places of abode. In the case of the first applicant, he provided 2 locations at Kuyinja LC1, Pampeo, Ward Kasanga Town Council, Wakiso District, and Rwakabengo A, Rwakabengo Ward, Southern Division, Lukonjiri Municipality in Lukonjiri District. And in the case of the second applicant, the location is Kisikula Village, Cell, Mutundwe Ward, Gombola Saragamo, Makindi Wakiso District. Also within the jurisdiction of this honorable court. Regarding pending charges, as for the applicant, submitted that the second applicant has no pending charges against him, and that the first applicant having a pending charge at the honorable court cannot be used to dismiss the second applicant's application as submitted by the respondent. Counsel further stated that the respondent has not provided any evidence of the stage at which the case at Uganda Road is, or whether in fact the first applicant has been put on his defense or found guilty. That he does not cease to enjoy the motion presumption of innocence because he has a pending case. Counsel for the applicant stated that the fact that the first applicant was charged with current offense while on bail in respect of the Uganda Road case cannot be used against him, as it is the same state that charged him that is now using those charges to argue that he should not be granted bail unless he re-offended while on bail. Regarding the possibility of interfering with the witnesses and the investigations, counsel for the applicants submitted that in Panju versus Ara, 1973, volume 1, it's African reports at page 282, it was held that the allegation of interference with the witness must be substantiated and that such substantiation is not difficult to show. Counsel submitted that there is no evidence that there has been placed before this court by the respondent to show that the allegation alleged strong likelihood of interference with the witnesses or investigations. Counsel prayed that this honorable court finds no likelihood of interference with the unknown witnesses or investigations and dismissed since the argument of the respondent on this point. While submitting in respect of applicant's age, counsel submitted that courts can, and in this case, should take judicial notice that prisons are not holiday destinations. That the fact that there are harsh conditions on remand has been taken note of, including in cases cited by the respondent, such as the case Augustine case. In respect of possibility of absconding, it was submitted for the first applicant and second applicant that since the arguments of the respondent seem to focus more on the first applicant, then the argument should not prejudice the second applicant, and that the evidence of the first applicant's mastery of the game, presumably referring to fleeing from Uganda, is not supported by any evidence. Counsel further submitted that the first applicant has demonstrated that in the past, when released on bail, and he required to travel outside the jurisdiction, he only undertook it with permission of the court. He would go out of the country and return. Regarding the sureties, it was argued for the applicants that the sureties presented were advised about their role of the honorable court, and none of them protested or said that they were unable to perform their roles. In the Kawangu's Insereko David versus Uganda, criminal insurance application number 426 of 2023, the court held as follows. It is my constant view that the role of a surety goes beyond the ability to forfeit the bond. Bail is not designed as an income-generating avenue for courts to which bail applications are made. What is pertinent about sureties is that there must be indication that they have been advised of their roles as sureties. They identify themselves properly and have shown and proved their authoritative relationship in respect to which the applicant showing that they are able to exercise their authority and command the appearance of the applicant in court when needed. As for the applicant, informed court that the sureties had been informed of their duties in respect of bail, which duties they understood well and committed to executing. Counsel further submitted that a proposed surety is required to provide a copy of his or her national identity card, and B, an introduction letter from the local council one chairperson of the area where the suit is ordinarily resident, as provided under bail guidelines. Counsel file submitted that the ages of the suites, which ranges from 27 to 58, demonstrate adult persons capable of understanding what they are undertaking, and that none is a minor and none is a person of extreme old age. Therefore, all suites have provided these documents. Citing the case of Chigongo Faro versus Uganda, rule application number 7 of 2024, cited with approval in the Makosa case, where the Honorable Court stated that I firmly believe that this court is in making its decision must be cognizant of the socio-economic environment in which justice is dispensed, particularly the informal nature of the employment of the majority of Ugandans, that makes it difficult to possess documentary evidence of capacity to meet monetary obligations. We insist on documentary proof of capacity to meet monetary obligations in the event that the suit is called upon to offend the bond, is to exclude sources of the population of Uganda from the opportunity to stand suit for relatives and friends. This would tantamount to discrimination against a section of the society on the basis of their socio-economic class. The courts have long held the view that if courts simply act on allegations, fears, or suspicions, then the sky is the limit, and one can have said no occasions when bail would be granted whenever such allegations are made. Counsel for the applicant submitted that the respondent provided no evidence rebut the grounds relied on by the applicant in support of their applications. It was prayed for the applicants that this honorable court finds that the applicants have each satisfied the requirements in the law and on the applicable facts to enable this honorable court to exercise its discretion in their favor and release them from custody on bail on reasonable terms. Determination. 1. Analysis of the law and the evidence. Article 23, 6A of the Constitution provides that where a person is arrested in respect of a criminal offense, the person is entitled to apply to the court to be released on bail, and the court may grant that person bail on such conditions as the court considers reasonable. Although the Constitution guarantees an accused person the right to apply for bail, the court at all times retains the discretion whether or not to grant an accused person bail. See Foundation for Human Rights Initiative versus Attorney General, Constitutional Petition number 20 of 2006. The primary principle for which a court may release an accused person on bail pending trial is the presumption of innocence. This legal principle is enshrined in Article 28, Sub 3 of the Constitution, which provides that every person who is charged with a criminal offense shall be presumed to be innocent until proven guilty or until that person has pleaded guilty. Section 15(1) of the TIA, in addition to upholding the right of accused person to apply for bail, clothes this court with the discretion to release an accused person on bail at any stage of the proceedings. Guideline 5 of the bail guidelines provides the general principles which a court may take into account while considering the bail application. The principles include the presumption of innocence, the right to liberty, applicant's obligation to attend the court, the discretion of the court to grant bail on such terms that the court considers reasonable, and the need to balance the rights of the applicants and the interests of justice. Having examined the applicable law on bail, I will now turn to the merits of the application. Right to apply for bail and the court's discretion to grant bail. This grant has already been addressed as above, and it is clear that the applicant has the right to apply to court to be released on bail with the court having the discretion whether or not to grant bail under Article 23(6) of the Prosecution. Presumption of innocence. The principle of presumption of innocence is a constitutional one, and as noted above, the bail guidelines require this court to consider the principle of presumption of innocence and personal liberty in determining bail applications. In relation to personal liberty, the active principle in granting bail is that of upholding the liberty of the individual while simultaneously protecting the administration of justice. See Abidi and another versus Uganda. Application number 20 of 2016. The presumption of innocence means that an actual person should not be taken in custody and deprived of his freedom unreasonably. Bail should not be refused merely as a punishment, and this would conflict with presumption of innocence. Fixed place of abode and substantiality of sureties. Fixed place of abode. A fixed place of abode for an applicant must be within the jurisdiction of this honorable court, as it guarantees the court that the applicant's accused person cannot be found, can be found in the event of absconding. To underscore the importance of the provisions of proof of a fixed place of abode, it can be a ground for refusal to grant bail. It is therefore imperative for the court to be persuaded that the accused person has a fixed place of abode, because it is a pointer to the fact as to whether the applicant is likely to abscond once granted bail. Section 16, subsection 4 of the TIA is instructive in this respect, as it provides in considering whether or not the accused is likely to abscond. The court may take into account the following factors: A, whether the accused person has a place of abode within the jurisdiction of the court, or is ordinarily resident outside Uganda. The point made in section 16, subsection 4, part A of the TIA is amplified by paragraph 13K of the bail guidelines. While the law does not define the phrase fixed place of abode, what is important is that fixed place of abode must be within the jurisdiction of the court, considering the bail application. Where the applicant fails to prove this under section 16, section 1 of the TIA, then the court may deny him bail. In the case of Foundation for Human Rights Initiative versus Attorney General Constitutional Petition number 20 of 2006, it was held that the nature of the offense and status of the applicants, and whether the applicants have a fixed place of abode in the this jurisdiction, should be strongly considered by the court in an application for bail. Remy Kasule J. Jenny Stephen versus Uganda defense application number 65 of 2004 held that the onus is on the applicant to satisfy the court that he has a permanent place of abode in a particular village, sub-county, and district. This is whenever the court exercises discretion, it exercises the illusion of the applicant, while on bail being able to trace his whereabouts whenever it is necessary. In respect of this application, the applicant said that under paragraph 3 of the notice of motion and paragraph 1 of the first applicant's affidavit in support of the application, that he has a fixed place of abode within the jurisdiction of this court at Wiyinja LC1, 1 Ward, Sanga Town Council, Wakiso District. And Rakabengo A, Rakabengo Ward, Southern Division, Municipality in Rukonji District, within the jurisdiction jurisdiction of this court. The applicant submitted a copy of his national identity card, the original of which is submitted for court inspection, and an introduction letter endorsed by the chairperson of Wenja LC1, one payroll ward, indicating that he is a resident in his area of jurisdiction. The second applicant says that he has a fixed place of abode within the jurisdiction of this honorable court at Kisibula village, Sel Motundwe ward, Mongolola Sabagabo, Makindi Wakso district, within the jurisdiction of this honorable court. The applicant submitted a copy of his national identity card and an introduction letter endorsed by the LC1 chairperson of Kisibula village, B. Selby, indicating that he is a resident of his area of jurisdiction. Paragraph 12A of the bail guidelines provides that an application for bail shall contain particulars of the applicant, accompanied by a copy of the national identity card, and an introduction letter from the chairperson LC1 of the area where the applicant resides. The village, parish, and district, as stated in the introduction letter, are well known and are within the jurisdiction of this honorable court. Excuse me. By furnishing court with a copy of the national identity card and an introduction letter from the chairperson LC1, the applicant has satisfied the honors placed on him to prove he has a permanent place of abode. C. Kayongo Bashir versus Uganda, criminal application number 158 of 2019. Therefore, the applicants have satisfied the requirements to prove a fixed place of abode. B. Substantial sureties. The term surety is defined by paragraph 4 of the Constitution, Bail Guidelines for Courts of Judicature, Practice, Directions, Legal Notes number 8 of 2022. To mean, a person who undertakes to ensure that the applicant will appear in court and abide by the bail conditions, and who furnishes security which may be forfeited to the state if the applicant fails to appear in court. Therein lies the main duty of a surety. What is pertinent about sureties is that there must be indication that they have been advised of their roles as sureties. They identified themselves properly and have shown and proved their authoritative relationship in respect to the applicant, showing that they are able to exercise their authority and command appearance of the applicant in court when needed. Section 16, subsection 4, part C of the Type A and paragraph 13, 1 of the Constitution, Bail Guidelines for Courts of Judicature, Class Directions, provides that in considering whether an active person is likely to abscond, the court shall consider whether the accused has sound sureties within the jurisdiction to undertake that the accused shall comply with conditions for his or her bail. Guideline 15 of the Bail Guidelines sets out 1. Factors that the court shall take into account in determining the suitability of a surety: age, work, and residence address, character and antecedents, relationship with the applicant, and any other factor court may deem fit. 2. Documentation with respect of a surety that must accompany an application for bail include a copy of the national identity card, passport of alien identification card, introduction letter from the LC1 chairperson of the area where the surety is ordinary resident. The applicants in the affidavits in support of the application are that they have sound and substantial sureties who have fixed places of abode within the jurisdiction of this honorable court, and in the event that they are granted bail, they undertake to ensure their compliance with all the terms set by this honorable court in the event that the applicants are granted bail. The first applicant presented four authorities as follows. 1. Honorable Semujunga Ibrahim, a 53-year-old male, member of Parliament of Kira Municipality, a resident of Oyogere Division, Kira Municipality. Honorable Semuju is the first applicant's close friend. On file, an introduction letter from the chairperson LC1 of Castle Cell, Kirinya Ward, Oyogere Division, Kira Municipality, indicating that Honorable Semuju is a resident of his area of Zizikon. And a photocopy of Honorable Semuju's national identity card. Honorable Semuju presented his original national identity card for court inspection. 2. Honorable Mohindo Herald Tony, a 53-year-old male adult, member of Parliament for Bukonzo County East, a resident of Katale Kusaula, Chengena Town Council. Honorable Mohindo is the first applicant's close friend. On file, an introduction letter from the LC1 chairperson of Katale Kusaula Cell, Chikato Ward, Chengena Town Council, Wakiso District, indicating that Honorable Mohindo is a resident of his area of jurisdiction, and a photocopy of Honorable Mohindo's national identity card. Honorable Mohindo presented his national identity card for court inspection. Photocopies of the documents are on record. Honorable Francis Mijuchi, a 41-year-old male adult, member of Parliament for Bukweju District, a resident of Bukete, Kelezia Cell, Mastori Ward, Kasanga Town Council. Honorable Mijuchi is a good friend of the first applicant. On file is an introduction letter from the LC1 chairperson of Unrelated Masori, Kelezia Cell, Masori Ward, Kasanga Town Council, Wakiso District, indicating Honorable Mijuchi is a resident of his area. And a photocopy of Honorable Mijuchi's national identity card is on record. Honorable Mijuchi presented the original of his national identity card for post inspection. For Honorable Kamara Nicholas Adias, a 50-year-old male adult, the MP for Kabale Municipality, a resident of Buye, Chigowa LC1 Bukoto 2 Parish, Nakawa Division. Honorable Kamara is a close friend of the first applicant. On file is an introduction letter from the LC1 chairperson of Buye, Chigowa 1 LC1 Bukoto 2 Parish, Nakawa Division, Kampala, indicating that Honorable Kamara is a resident of his area, and a photocopy of Honorable Kamara's national identity card is also recorded. Honorable Kamara presented the original of his national identity card for post inspection. The second applicant presented three sureties as follows. Nagita Karima Lutale, a 58-year female president of Kisugu, Makindi Wakiso District. She is the wife of the second applicant. She is a businesswoman engaging in business with her husband. She presented an introduction letter from the LC1 chairperson of Kisukula Village Cell, Mutu the Ward, Gombola Sabagabo Makindi Wakiso District, indicating that she is a resident of his area. Mrs. Rutale presented the original national identity card for court inspection. 3. Tuankam Hamza, a 48-year-old male resident of Kanabe Village, Ndege Parish, Sabagabo Makindi, Wakiso District. He's an advocate practicing with the Soankambo and Company Advocates. Mr. Soankambo is a brother of the second applicant. He presented an introduction letter from the LC1 chairperson of Kanaba Cell, Ndenje Ward, Ndenje Division, marking the Sabagabo Municipality, Wakiso District, indicating that he is a resident of his area. Mr. Sewankabo presented the original of his national identity card for court inspection. 3. Nafuka Zura, a 27-year-old female, resident of Kulikonge Parish, Chiaba Zone, Kampala District. She's a journalist by profession. Ms. Nafuka is the daughter of the second applicant. She presented an introduction letter from the LC1 chairperson of Chiaba Zone, LC1 Kulikonge Parish, Makindi Division, Kampala District. Indicating that she is a resident of this area. Ms. Nafuka presented the original of her national ID card for court inspection. By presenting the originals of their national ID card, the letters of introduction from the chairperson LC1, where they ordinarily reside, the sureties satisfy the conditions set out in Guideline 15 of the bail guidelines. The aforementioned guidelines do not provide guidance on the format the introduction letter should take and what it must state. Neither do they make reference to permanency of residence in terms of owning property, as alluded to by the respondent by his reference to land titles and sale agreements. I am not persuaded by the respondent's argument that the first applicant's sureties are not suitable as sureties, on the fact that they are friends and not blood relatives, younger than the applicant, and therefore are not able to execute their duties as sureties. The first applicant's sureties are his close friends and leaders in a political party of which the first applicant is a member. By virtue of their position as close friends of the first applicant and leaders in a common political party, they are able to exert influence over the applicant to ensure that he abides by his bail terms in the event that he is released on bail. The fact that
Extreme Media UK.
Notwithstanding, reference to A in the bail guideline as a parameter for determining suitability of a surety does not indicate that the surety must be necessarily older than the applicant. It is enough that the surety is a responsible adult with a connection to the applicant, capable of exerting influence on the applicant to comply with his bail terms. In the premises, I found the first applicant's sureties substantial sureties capable of exercising authority over the first applicant to ensure that he abides by the conditions of bail in the event he is granted bail. The second applicant's relationship to his sureties as husband, father, and brother respectively. The fact of their being younger than the applicant notwithstanding, in my view, arguments their ability to compel him to comply with his bail conditions in the event that he is granted bail. It is enough that the sureties provided copies of their national identity cards and introduction letters from local council chairpersons of the areas where the sureties are ordinarily resident, are set out in paragraph 15 of the paragraph 15 2A and B of the bail constitutional guidelines for courts of judicature, Trust Directions 2022. The aforementioned guidelines do not provide guidance on the format of the introduction letter that should take and what it must state. Neither do they make reference to permanency of residence in terms of owning property, as alluded to by the respondent by his reference to land titles and sale agreements. Accordingly, the declared relationship between the sureties as close friends presented by the first applicant arguments their suitability as sureties. Also, the declared blood relationship between the second applicant and his second and third sureties and the relationship of the first surety as the wife of the first applicant arguments their suitability as sureties. Although, as one of the factors considered in determining the determination of sureties, the bail guidelines mention age. It does not, in my view, indicate that the surety must always be older than the applicant. It is enough that the sureties are adults in positions of responsibility or so as so connected to the applicant that they are able to exert pressure on the applicant to comply with their bail conditions if granted bail. To say that a surety must always be older than the applicant is to set a dangerous precedent. Where senior citizens of very advanced age may never be granted and may never be able to find sureties who are older than them. I therefore find that the first and second applicants have satisfied the requirements to present substantial sureties. Exceptional circumstances. It is settled law that existence of exceptional circumstances is no longer mandatory for bail to be granted, as bail can be granted even where there are no exceptional circumstances. Uganda was a retired Colonel Dr. Kiza Besigye Sopra.
Banango liko Extreme Media yugi subscribing liking atera commenting omulamuzi akaye omulamuzi ne dokita asese guys tova konga to subscribing nze you're watching Extreme Media yugi.
That proof of exceptional circumstances in an application for bail is not mandatory. In this application for bail, however, the first and second applicants lie on the adverse age as their exceptional circumstances. Section 16, Section 3, Part C of the Child Act provides that exceptional circumstances include the infancy or advanced age. There is no doubt that the applicants are 68 years, 65 years old, respectively, are of advanced age. The applicants have succeeded in proving exceptional circumstances in the context of Section 16, Subsection 3, Part C of the GIA. In this case, the applicants have proved that they have a fixed place of abode, substantial sureties, are of advanced age. Both applicants have not been found guilty of any offense previously, while the first applicant has charges pending against him at Uganda report. The second applicant has no other charges pending against him. The first applicant was released on bail in respect of the charges pending against him at Uganda report. By interpretation of the other charges against the applicant does not extend to charges in respect of which the applicant was released on bail, and has not been proved that before he had deliberately or for no justifiable reason failed to abide by bail terms. Grant of the offense, nature of the offense, and possibility of delay of commencement of trial. As for the applicant cited the case of Makoha, Samuel, and 35 others versus Uganda, where the applicants were granted bail while being charged with terrorism, contrary to Section 6, Subsection 1B, and Section 2, and Subsection 2, Part B of the Terrorism Act. It was submitted for the respondent that the applicants in this case of Makoha, Samuel, and 35 others versus Uganda are charged with terrorism, which attracts life imprisonment on conviction, while the applicants in the present case are charged with treason, which attracts a sentence of death upon conviction. That on the scale of gravity, the charges against the applicants in this case the ultimate penalty, and therefore are braver than the charges against the applicants in the case of Makoha, Samuel, and 35 others versus Uganda. While the charges in both cases are raised the charges in the present case, in the present application, are more serious. Counsel for the applicants stated that the International Crimes Division of the High Court held in granting the applicants bail in the Mapoka case said that despite the gravity of the allegations against the applicants, this court must determine whether sufficient evidence is presented to indicate the guilt or innocence of the applicants. In that case, the prosecution stated in their affidavit in opposition of the application that there was sufficient evidence against the applicants. In the present application, the respondent has stated that the investigations are still ongoing and has not made any assertions about sufficiency of the evidence against the applicants, based on the evidence so far adduced. This court is therefore unable to make a determination on the sufficiency of evidence pointing to the guilt or innocence of the applicants. In Uganda DPP versus Colonel retired Dr. Kiza Besigye, motion reference number 20 of 2005, it was stated that in relation to bail, the extent to which evidence is pointing to proof of guilt or innocence of the applicant would seem to be one of degree in circumstances of a particular case. Counsel for the applicant submitted that no evidence has been adduced in support of the averment that the offense impacts on the national security of Uganda. It was added that the investigators have placed nothing before this court to suggest that there is evidence of any nature at all, or suggest that what they affirm. In their response to this point, as for the response submitted that the charges with which the applicants are charged, treason, involves violent change of government. I am inclined to side with the respondent that treason being an offense that involves overthrowing government, which act is accompanied by violence, an act of treason impacts on national security of Uganda. Possibility of interference with investigation and witnesses. It was submitted for the applicant that there is no likelihood of the applicants interfering with the witnesses. As for the applicant cited Banjo versus Arab, 1973 Seminal Report at page 282, where it was held that allegations of interference with the witnesses must be substantiated, that such substantiation is not difficult to show. In reply, as for the respondent submitted that the first applicant is a prominent and influential person, and the second applicant is his personal assistant, that in releasing them on bail, will afford them the opportunity to interfere with witnesses and investigations which are still ongoing. As for the respondent, on the case of Okelo Augustine versus Uganda, application number 6 of 1012, where the court emphasized that once the likelihood of abscondment and interference with investigations have been established, the court should be instant grant bail. In this case, the respondent said that the applicants are very influential people with the ability to interfere with investigations. Although the respondent has not gone ahead to say in detail how the applicants are likely to interfere with the investigations which are ongoing, the particular circumstances of the case against the applicant must be borne in mind. The offences are said to have been committed in various jurisdictions, and the charges are extremely grave. I agree with the respondent that the applicants are very influential people with the wherewithal to interfere with the likelihood to interfere with the investigations which are still ongoing. Decision. The main consideration for bail for release the main consideration for release of an accused person on bail and the right to liberty and presumption of innocence. Article 23 of the Constitution provides that no person shall be deprived of personal liberty except the execution of the sentence or order of a court, whether established for Uganda or another country, or of another international court, or tribunal in respect of a criminal offense, of which that person has been convicted, or of an order of court punishing the person for contempt of court. Article 28, 3A of the Constitution provides every person who is charged with a criminal offense shall be presumed to be innocent until proven guilty or until that person has pleaded guilty. Article 23, 6A of the Constitution, in recognition of the fact that liberty may be curtailed even where the sentence or order of the court is pending, provides that where a person is arrested in respect of a criminal offense, the person is entitled to apply the court to be released on bail, and the court may grant that person bail on such conditions as the court considers reasonable. Article 23.6 of the Constitution entitles accused person to apply to court to be released on bail. It is clear from Article 23.6a that accused persons, irrespective of the gravity of the offense, are entitled to apply to be released on bail. However, the discretion remains with the court to grant or reject the application for bail. See Uganda versus Colonel, retired Dr. Giza Besigye, National Reference number 20 of 2005. Among the considerations for exercise of this question is the grant of the offense. Courts will be more readily grant bail or less for less serious offenses than the serious offenses. The offense with which the applicants are charged are among the gravest, if not the gravest offenses of our statute books. In all cases where applicants are charged with capital offenses, the court must always have in its mind the overarching consideration of the gravity of the accusation against the applicants and the sentence that it attracts. As stated in the case of Okelo Akasne versus Uganda, Supra, while acknowledging the release of one accused person on bail is reminded on the right to liberty, there should be peace and safety of the people and their property. The court of law and all other organs of government have a duty to ensure that national and international security is preserved. Therefore, the fundamental rights of the individual must be balanced with this greater public interest. In this regard, the court has to consider whether there is justification to interfere with the accused person's right to liberty pending his or her trial. The summons of the present case are that it is alleged that the offences were committed by the accused persons in various jurisdictions, including Kenya, Greece, Besigye, and Netherlands, with other persons still at large. The investigation into the charges against the applicants have not been concluded. By the fact that the offences are alleged to have been committed in various jurisdictions, investigations are unlikely to be wrapped up as speedily as investigations in the specific offences alleged to be committed only in Uganda. It was argued for the applicants that their continued incarceration, while investigations which do not have a clear timeline of conclusion are ongoing, is prejudicial to them, as it is not clear when the investigation will conclude, to facilitate the committing of the applicants for trial to the High Court. As for the applicants, says that there will be therefore this substantial delay in commencing the trial. Article 23.6c of the Constitution provides that where a person is arrested in respect of a criminal offense, liable only by the High Court, such a person shall be released on bail on such conditions as the court considers reasonable. If the person has been remanded in custody for 180 days before the case is committed to the High Court, I am of the opinion that This provision takes into account circumstances like the summons of this case, where a person, where one reason or another, investigation cannot be concluded speedily, and provides a cap on the time on remand, without committing beyond which time the accused person shall be mandatorily released on bail. Safeguard against the right of the accused person to liberty being indefinitely curtailed. Where the applicants for bail have not yet blocked mandatory bail, bail is a matter of court's discretion, as provided under Article 23(6)(a). In this case, the applicants have, among other factors, proved they have a fixed place of abode, have substantial securities, are of advanced stage, and are of first-time offenders, since they have never been convicted of any criminal offense. It has also not been proved that on a previous occasion, when granted bail, the applicant did not abide by the bail conditions. While the first applicant has charges pending against him at Uganda Court, for which he was released on bail, the second applicant has no charges pending against him. As stated in John Hango's Kashaka versus Uganda, Supreme Court, License Application number 18 of 2023, all factors of the bail application, all factors of the bail applicant's rates, including being a first offender, being advanced age, having a fixed place of abode, received the background when weighed against the seriousness of the offense. In Young Zeng John versus Uganda, Court of Appeal of Uganda, License Application number 99 of 2013, it was stated that the granting of bail by court one before court is essentially an act of the exercise by court of its discretionary powers. The court considers all that is before it regarding the application for bail, and reaches a decision based on the rules of reason, justice, and law. Therefore, although I find that the applicants have satisfied all the relevant requirements for grant of bail, such as proving that they have fixed places of abode, have substantial securities, are first offenders with no criminal record, and are of advanced age, the application for bail is denied for the following reasons. 1. The charges against the applicants are among the gravest, if not the gravest, on our statute books. The offences are alleged to have been committed in various locations in Uganda and in other countries, requiring more time and resources to conclude investigations than is normally the case in offences alleged to have been committed only in Uganda. Owing to the fact that the investigations are ongoing, the interests of justice at this point indicate that the application for bail is denied on this occasion because there is a likelihood that the applicants, if released on bail while investigations are ongoing, owing to the grave nature of the offense, may fall prey to the temptation to interfere with the investigation. Signed, Rosette Comfort Tanya, Judge, 11th April 2025.
Bamumye Dairo omusajja.
We shall overcome someday. I do believe we shall overcome someday. Let's go! Let's go!
Bannange kimulina omanya omusajja bamumye Dairo neera. Don't go without subscribing. We are going to get interviews. And now, what you need to do is subscribe, like, and tell bannange mbeera omulenzi oyo golaba mukuya alina masike balina pasito omusajja golaba alina masike alina pisito oyo Alright, obanga gwe muloni gw'ogulaba kono ku Extreme Media UG, please don't go without subscribing. Abantu babadde babaze mungi mu bungi nnyo. Please subscribing ate video z'okunywa kamala tubeere nga tusobola okuba nti mutukuweereza. N'ekirala kye njagala okuyisaawo wano bannange, ekirala kye njagala okuyisaawo wano wennyini munoonyeko kyano gye bayita the Uganda Updates. Naye mugende mu gisubscribingeko tulwana kuweza basubscribers nga 1,000. Tutandika obaweereza nga tuli strong segimesayo.
Okay.
Also, the case of the offenses, it is not really decided which offenses, it's still decided the state will decide. So that means any one of us can decide to prison and Yes. They don't need evidence. No nonsense.
Guys, bali ku Extreme Media UG, subscribing ale government ino amazima abantu bangi nnyo
kiruma nnyo kaka wako yali atta abantu bangi
bannange.
He's a journalist. Doctor, this guy is a journalist. Wonder what? You are a journalist, you go down.
Nanga kavuyo kali wano deployment y'amaanyi nnyo. Batuganye kuka wansi.
Eggwanga likukoye bose bamala eggwanga likukoye bose bamala
batuganye okuka wansi deployment batuganye okuka wansi.
eggwanga likukoye bose bamala eggwanga likukoye bose bamala eggwanga likukoye bose bamala eggwanga
Supreme Court
bose bamala eggwanga likukoye bose bamala eggwanga likukoye bose bamala eggwanga likukoye bose bamala eggwanga likukoye bose bamala